Hello friends, in the series on the income tax cases, today we will discuss a very important case on bogus purchases. It has been seen that in case of bogus purchases, whenever the assessee get relief either from CIT appeal or tribunal, where the addition of the alleged bogus purchases is pegged up to a certain percentage and the quantum of the addition is not very big, then the assessee thinks that the assessee will pay tax on that and will not contest that matter further. If the assessee do not contest even the percentage basis addition of the alleged bogus purchases, then whether that non-filing the appeal against those orders can give a inference that the assessee has not been able to prove his transactions, and that's why he accepts some percentage based addition, or in other words, by accepting the percentage based addition, the assessee accepts that he is not able to prove the transactions, and that can be very fatal to the assessee. This has been decided by the Honorable Bombay High Court in the case of Principal Commissioner of Income Tax versus SHREE Ganesh Developers. This case is reported in 476 ITR at page number 568 and the date of the judgment is 5th March 2025. The present case relates to the assessment year 10-11. The proceedings under section 143 subsection 3 scrutiny proceedings were going on, and during the assessment proceedings the learned assessing officer made addition of the alleged bogus purchases under section 69C for the total alleged purchases and some additions under section 68 for unexplained credit. When the matter was before the CIT appeal, the CIT appeal sought a remand report from the AO, and the AO in his remand report said that the AO has done the detailed verification, and in respect of purchases except two, all the parties have responded to the notices under section 133 subsection 6. They have given the bank statements, and the assessing officer also verified from the bank and recalled the bank statements of those suppliers and found that in those bank statements no cash has been withdrawn after the payment made by the assessee to those suppliers. But in respect of two suppliers, the bank statement was not available. So the CIT appeal on the basis of remand report of the assessing officer deleted the complete addition of the alleged bogus purchases except two suppliers, and in respect of two suppliers pegged the addition on the estimation basis at 12.5%. The revenue filed the appeal in the tribunal for the deletion by the CIT appeal of the alleged bogus purchases and for the remaining two suppliers at 12.5%. But the assessee didn't file the appeal for the addition at the rate of 12.5%. When this matter was before the Bombay High Court, the court said that as far as the deletion of addition in respect of the remaining purchases is concerned, the remand report of the assessing officer clearly says that the purchases were genuine, all the notices has been complied with, and the bank statements were there from where the assessing officer was able to verify that no cash has been withdrawn. So as far as the deletion of addition was concerned in respect of the remaining purchases, that is justified. But as far as the deletion or the restriction of the addition at 12.5% of the two alleged suppliers, the court said that there was no bank statement available with the assessing officer, and since the assessee has not filed the appeal against that addition, so it means that the assessee is not able to prove the genuineness of those transactions, and in that case for the lower authorities there was no justification to restrict the addition to 12.5% in respect of those purchases. The court said that the lower authorities would not have confirmed the addition to 12.5%, and the whole addition should be there under section 69C. So friends, in the present case, whenever there is a matter of alleged bogus purchases, then the assessee should try to make available the bank statement of the suppliers and ensure that there is no cash withdrawal from those statements, and try to comply with the notices under section 133 subsection 6 by those suppliers. At the end of this video, once again I am repeating the name of the case. The name of the case is Principal Commissioner of Income Tax versus SHREE Ganesh Developers, and this case is reported in 476 ITR page number 568, and the date of the judgment is 5th March 2025. Thank you friends.